Welcome, everyone. Thank you so much for joining us for today's Appraisal Buzzcast. We've got a great one for you today. I'm Jim Morrison, and today we have Joan Trice, CEO and founder of Allterra Group, and Peter Christensen of Valuation Legal. We'll be talking about an important topic that's making the news, and you need to hear about it. Joan, I'll hand it over to you.
Thank you, Jim, and welcome, Peter. We're always happy to have you join us on our podcast, and we've got kind of a hot topic today. So tell our audience, I'm hearing about there's a legal challenge with floor plans and sketches, and my intel is a little sketchy on this, pardon the pun there, but would you tell the appraisers in the field what's going on?
Yeah, it's a case that has attracted interest outside of appraising circles as well, and outside of real estate agent and broker circles. It's a copyright case that is now before the Supreme Court. Parties are asking for the Supreme Court to review this case. So maybe I should go a little bit back to the beginning about the case to explain how it got to where it is and why all these parties, including the Appraisal Institute, REVA, CoreLogic, the ASA, Massachusetts Board of Real Estate Appraisers, they've all joined together to file a brief to ask the Supreme Court to accept the review and reverse this case that I'll talk about. So maybe I'll just go back a little bit to the beginning here. The story of the case is that back in the mid-1990s, a developer built a series of houses in Columbia, Missouri. So I'm going to focus on one of the houses. In 1996, he built one of these houses. So people bought the houses. In 2010, in this particular house, so 14 years later, in 2010, one of the owners of these houses was going to sell the house. So they engaged a real estate agent to list the house on MLS and to do flyers and things like that, to advertise the house for sale. And in the course of doing that, their agent created her own floor plan. She measured the house, and on scratch paper, she actually drew out this floor plan. So let me share this floor plan that we're talking about here for just a second. So this is actually one of her advertisements, the agent's advertisements for this home, and this is back in 2010. And so this is the floor plan that she drew. It's pretty nice, self-done floor plan by an agent back in 2010 when all the fancy technologies didn't exist that might exist now. She did this on scratch paper. She's got the various rooms labeled. It's, I've taken this out of a legal brief, so we can't get all the detail. Right. But she's got the room sizes on there. It's a 2-story house that you can see here in the picture. So you drive in on this level that faces the street. And then this is the second floor here. So this is what it looks like from the street. And then this is what it looks like from the back. The developer, I'll tell you in the legal briefing, the developer designer of the houses was very proud of this little bump out here, this triangular bump out. He thought that was a really special element. Here, I have another picture here in the next slide. There's a second house that's involved. That's actually pretty identical. So this is how that house looked like from the back. Here's that little bump out. And here's another floor plan, because there are 2 cases that have been combined, but it's basically the same house design. So another floor plan, a bit more professionally done. This was done by a contractor or someone who actually had some tools to create real floor plans. So those are the floor plans that we're talking about here. So I'll stop sharing that screen. That agent lists that house in 2010. Well, I think the house gets sold. That's not really the key issue. In 2018, so 8 years after, and more than 20 years after that house was built, the designer of that house sues that agent, sues the agent for copyright violations, asserting that her little self-done floor plan violated the developer's copyrights to the house. So this, the lawsuit didn't assert that she copied architectural plans. No, she went out and measured this house herself, created her own floor plan. The issue here is that with architectural copyrights, when you design a house, they usually, would be an architect, they own the copyright to the house, not just to the drawings. They can register copyrights over drawings too, but they own the copyright to the whole design of the house, the architectural elements, the layout of the rooms, maybe the room sizes, where the chimney is, that little triangular bump out. So the assertion was that her publication of that floor plan violated his copyrights to the house. So he sues her in 2018. Well, there is this exception in the copyright law that says, because think about it. There's you take a picture of somebody's house, are you violating a copyright? No. Yeah. Or think about this. You want to take a photograph of your own house and I don't know.
Put it on Zillow.
Yeah, put it on Zillow. Does that violate a copyright? No, it doesn't, because there's an exception in the copyright law that relates to architectural works. And the exception is that the copyright protections don't extend to photographs, pictures, pictorial representations, paintings of architectural works. That's the exception. So the agent being sued by the designer of the home, and what he's really going for is, in copyright law, if you have a registered copyright, if someone violates your copyright, you can get statutory damages up to $150,000 per violation. So it's not even a matter of, was the owner of this house design actually financially injured? He's not actually seeking actual damages. He's seeking these statutory damages. He's really trolling for victims here. So the agent now attracts attention, and there are other cases that the same designer has filed at the same time, or a home developer has filed at the same time. The agent files a motion to get the case dismissed based on that exception that we just talked about, and the trial court, federal court in Missouri, dismisses the case. But then the developer appeals to what's called the Eighth Circuit Federal Court of Appeal that handles cases in that area in Missouri and other nearby states. And the Circuit Court of Appeal actually reverses and finds that exception does not apply to floor plans or diagrams, sketches, drawings, like technical drawings of a house. The Court of Appeal finds that exception doesn't apply. So now the agent broker has a real problem. She could be potentially liable for copyright damages to this developer. And so I mentioned there are a couple other cases floating in the background. There's another case about very similar house design gets put together with this case. The defendants there also lose. They now appeal that Court of Appeal decision to the Supreme Court. So now, in spring of this year, they asked the U.S. Supreme Court, please accept review of this Eighth Circuit decision, and please reverse it. So now it's up to the Supreme Court whether they accept review. So how does this impact appraisers? Well, I think it's probably occurring to you that appraisers often have floor plans, sketches. Now, I'm not talking about just residential, I'm talking about commercial too.
Yeah, I know.
They often have floor plans, sketches in their appraisal reports. Sometimes they're mandated by in certain instances by Freddie or Fannie Mae requirements, in some cases to actually have a floor plan. And so then that leads to the question, does an appraiser's creation of their own floor plan violate the copyrights to whoever owns that house design? That's the issue. And so just to round it out then, Joan, so that appeal gets filed to the Supreme Court in spring of this year. And then the Appraisal Institute, companies that specifically make products that will create a floor plan out of a video, company called Cubicasa, another company, CoreLogic, Riva, Clear Capital, the National Association of Realtors, I shouldn't have left them out. They all joined together, 18 different companies and organizations joined together to file what's called an amicus brief to reinforce that request that the Supreme Court review this case. And they specifically pointed out in their brief that if this case isn't reversed, there's this threat that people like appraisers, they specifically pointed out, people like appraisers, but also we have the agents and brokers in the situation I just described, but also people who make a diagram of a house for insurance coverage, people who make a diagram of a house to remodel it, people, lots of different examples of floor plans being used. The issue is then if this case is not reversed, you will have more trolling, more cases filed against parties possibly like appraisers or the big companies that make these floor plans. So that's why this is an important issue and why 18 different companies and organizations have really banded together on the appraiser side of this to try to get the case reversed. Now, I want to point out, there is another defense here that the Circuit Court of Appeal said that this exception in the copyright law doesn't apply. Doesn't mean that the agents and brokers have totally lost the case yet. There is another defense called the fair use defense. And so the question would be, is an appraiser's creation of a floor plan fair use of that copyright? That is another defense, and the agents and brokers, if they have to go forward with this case and defend themselves, they'll assert that defense. But the problem with that defense is it's highly factual specific. So it really twists and turns on different weighing of factors. It's not a great, like, silver bullet defense. So expensive to make. So sorry for that long introduction.
That's all right.
That's the story of the case, and that's where we're at.
That's a lot. So let's do this. Let's take a quick commercial break and we'll be right back.
Yeah.
Whether you're looking for an authoritative textbook or detailed information on current valuation issues and specific property types, you'll find what you need at the Appraisal Institute store. To choose from more than 70 print and digital publications, shop appraisalinstitute.org/store.
Welcome back, everybody. So, Peter, I had a question sort of at the very beginning of your description. You said that there's an exception for, I think, using a rendering or drawing. I don't understand, I'm not an attorney. I don't understand why this isn't a rendering. These are not usable architectural or engineering drawings that somebody could reconstruct that house from.
Yeah. And I think a lot of people, even some courts, would see it the way that you're seeing it.
Yeah, it seems ridiculous to me.
They would see. Here's the specific exception, and it specifically applies to architectural works. So the copyright law, which is federal statutory law, says that the copyrights to architectural works do not include the right to prevent taking pictures, making paintings, taking photographs, or making other pictorial representations of the work, as long as that house or building is in a public place or visible to the public. So a lot of people would understand those words to mean what you just said.
Yeah,
hey, doesn't that mean a floor plan or a diagram of the house? As long as it's not like maybe you can't build a house from it.
Yeah.
And so, I think that's a fair understanding, but unfortunately the Eighth Circuit Court of Appeal didn't go that way. They looked to some other technical parts of the copyright law and saw where there were distinctions in the copyright law between technical drawings and photographs or pictorial representations. So they went into other parts of the copyright law and saw, hey, in other parts of the law, there's this distinction between drawings and pictorial representations. So, but the problem is this is really the only case out there, appellate case, that looks at this issue and looks at floor plans. And so that's the problem. It's if this case stands like it does, with what many people would call an erroneous application by the Eighth Circuit, we got a problem because it becomes precedent, and then other lower courts, district courts, would enforce it quite possibly the way that the Eighth Circuit Court of Appeals sees it. That's why all these groups have banded together to try to get the Supreme Court to accept review and reverse it.
Well, let me ask you a question. Many counties, not all counties, have floor plans in their public record data set.
Yeah.
Um,
Yeah, and that's been pointed out as an issue by the parties who want review of the case. They've said tax assessors have this in, have tax assessment people, whether it could be a challenger or it could be the tax assessor themselves, go out and make pictures of, or not pictures, or they go out and make drawings of homes. Is this a violation? And it quite possibly is a violation to which this exception doesn't apply. But then you still have, okay, there's this other defense out there, and the Eighth Circuit Court of Appeal, the one that we were trying to get the decision reversed on, they did point out there's still this defense called fair use. And so maybe we could talk a little bit about the fair use.
Yeah, let's do, because I'm confused.
So what's nice about the exception, if it applied, is that it's just like crystal clear. Okay. So what if floor plan were included in the words in the statute that it's okay to make a floor plan of a house or a building, doesn't violate copyright? That's a clear exception. And that's what is lost by this decision. So even this Eighth Circuit Court of Appeal said, no, but there's still this defense, and it's the fair use defense. And so, so fair use, in a typical setting, fair use defense to a copyright like claim is like, okay, you're a book reviewer. Okay, in your book review, you take parts, little snippets of the book, and you put them in your book review. That's fair use. That's a very good, If the writer of the book sued you for a copyright violation over your book review, they're almost certainly going to lose that, because that's a fair use of bits of their copyrighted work. A film critic could show parts of a film without worrying about copyright violation. A film critic couldn't just go, oh, let me blast this 2-hour movie, and then I'm going to review it at the end, and I'm going to put it up. No, okay, you can't do that, because that's not fair. That's not fair use anymore if you just blast out the whole work. But it's a balancing of factors test. And so it's really, okay, how much is that use interfering with the value of what is copyrighted? So let's make it more specific to an appraiser putting a floor plan in their appraisal report. I think the appraiser has a pretty good shot with the fair use defense, because the purpose of the appraisal report is not to replicate this architectural work. It's just like, hey, I'm got this little drawing of it. I'm going to talk about the house in my appraisal report. It's a transformative kind of use.
Right.
It doesn't interfere with the architect's ability to sell house plans. No one's going to build a house out of the floor plan in an appraisal report, right?
Correct.
So the fair use defense is, I think it's good, but the problem is it's like this balancing of factors. It's not the silver bullet that you get. So maybe we have really good defenses for appraisers and about individual appraisal reports. Maybe they won't be as threatened by this issue. But what if you're a company whose business is like, I sell a gadget,
the technology, to draw these floor plans, and wow.
I sell this technology that lets you use your iPhone to go around a house and create a perfect floor plan. Now, if I were that company, I'd have some serious concerns if this case isn't reversed.
Right.
So that's
but it's not only these for-profit enterprises who are building the technology to modernize the appraisal process, but obviously Fannie and Freddie's policies are what's driving this. So the GSEs have got to be watching this very, very closely. I have no doubt.
I would definitely say that, I don't know how many lawyers they have. They've got at least one lawyer looking, following this case, each of them. Because if this case isn't reversed, they're going to have to say, please don't give us a detailed floor plan anymore. Do like a really rough sketch or something,
Right.
That requirement would change, I would say, because nobody wants to risk this kind of thing. And what'll happen if this case isn't reversed, there will be a lot of developers, architects, house designers who come out of the woodworks, and now they are just trolling They are
Right, for
filing
lawsuits.
lawsuits.
Yeah,
It
oh,
will,
joy. Yeah.
yeah,
Got
it'll
the
take,
ambulance
yeah,
chasers out. Right.
yeah.
Great. Hey,
And
Peter,
now certainly agents or brokers for NAR, this is I would say an even bigger issue because their agents and brokers are publicly taking that house,
oh yeah. Yeah.
and putting it,
And yeah, and it
and
ends up
advertising.
on NAR's website,
Yeah.
realtor.com and Zillow and other aggregators. Absolutely.
Yeah.
Well, let's take another quick break and then we'll talk more about this complex issue.
Are you ready to meet the new GSE requirement of a detailed floor plan for your desktop appraisals? Remote Val, a remote inspection app designed for appraisers, has a 3D video scan feature which creates a detailed floor plan for you can submit with your report. Remote Val's live virtual inspection technology allows you to personally verify the data at the same time. You can also supplement missing photographs using the remote photography feature. Incenter pays you the same full fee for Remote Val inspections. Desktop appraisals have never been faster, easier, or more trustworthy. To see a demo of Remote Val in action, visit incenteram.com.
So, Peter, what happens from here? I mean, there's a lot at stake here in our little space. So, what if it win? What if they win? What if they lose? What next? And how long does all this take?
Well, how long is it? Yeah. So what's going to happen from here? So the briefing on this issue of should the Supreme Court accept review isn't quite done yet. It'll be done in like the next 30 days, but then the Supreme Court goes on a summer break. So we probably won't know until September, October, if the Supreme Court will just accept review of the case. So we won't know about that for a while. So then this is a really interesting case. I think there's a good chance that the Supreme Court will accept review. This is really interesting. And there are a lot of parties who are interested in this. So I think there's a good chance that the Supreme Court will accept review, and then a good chance that it would be reversed. So if that happens, okay, everything goes back to normal, because now we would know that this exception applies to floor plans, right? But if the Supreme Court doesn't accept review, or if it does and doesn't come out the right way, the court doesn't reverse the case, well, then I think we'll see some changes. I mean, agents and brokers certainly won't be putting floor plans on the MLS.
Well, they hardly do now. So certainly this would
I'll guarantee you
back. Yeah.
If the case is not reversed, we won't see floor plans on the MLS or in Zillow or anywhere else.
Right.
In the future. It'll be like, you can't use copyrighted music on YouTube.
Right.
They have bars against that, right? It'll be like that. Just
right.
You probably see GSEs saying to appraisers, hey, no more floor plans. And so you will see changes. You might even see Congress amend the Copyright Act if this case is not reversed. Because one amendment, like a few words in that exception, takes care of the whole problem.
Well, so NAR is a pretty big lobby.
Yes.
So yeah, they have a lot at stake here.
So, so until that wording in the statute changes, you'd see like no more floor plans. Then, okay, maybe the statute gets changed, because this exception itself wasn't even created until 1990. So it's not like it's been around forever. Just as a sideline, interesting issue. How long does the copyright of the architect or home designer builder last? Yeah. The copyright exists until 70 years after that designer's death. So it's a long-term problem. Anyway, that was just a little bit of a sideline.
Are there other copyright issues within the appraisal space?
I've seen some this is rare. I don't want to scare appraisers. I have seen appraisers be sued by makers of different kinds of mapping.
Oh yeah, systems. That's right. No, I haven't seen those in years, but yes.
You drop a picture of someone's copyrighted map into an appraisal report. I've seen an appraiser be sued over that.
Yeah.
Let's flip that.
And that's a practice that every appraiser in the United States was doing all day, every day.
Now it's a rare
make
claim.
It legal, but yeah.
Yeah. It's a really rare claim because, appraisal reports are not seen by that many public eyes, right?
Right.
Yeah. Okay, but flipping the tables a little bit. What about an appraisal report? Who owns the copyright to that? So let's say, it's the appraiser who creates it. Let's say There aren't any agreements in place where the appraiser gives ownership of that appraisal report to somebody else. So let's say the appraiser owns the copyright to their own report. Have appraisers ever sued other parties for violating the appraiser's copyrights over their report? Yes, that's happened. I've seen there's a fairly well-known case
Yep.
of a
Yep.
commercial appraiser who sued some brokers who used his copyrighted report as part of their sales tools. He did an appraisal report for a lending purpose, something like that. And then it was misused by the brokers as a sales tool. He actually sued and had some success with his lawsuit for copyright violations. So copyright does come into play in other ways in appraisal reports.
Well, but wasn't this sort of, I mean, we talked about this a lot, at least a decade ago, as I recall. And I believe, I don't recall if it's in the certifications, but I thought the conclusion after all the dust up was that an appraisal is a work for hire.
We're No.
Okay.
No. Oh, an appraisal report is not a work for hire in most circumstances. The work for hire is a way of, say a work for hire, the work for hire, if it's applied, would mean, hey, I paid that appraiser to do that appraisal for me and to give me that report. So I own that report because it was a work for hire. That would be the assertion, right?
Okay.
Works for hire, that concept only applies to the work of employees. It does not apply to the work of an independent contractor.
Okay.
And so if you're an AMC, say, and you're telling appraisers that their work is a work for hire, that's a dangerous tactic to take, because by saying that, you're saying that these appraisers are your employees when you really need to treat them as independent contractors.
No, exactly.
Okay, so that's why I went a little bit nuts when you brought up works for hire. What is the clearer way of dealing with this between appraisers and AMCs and lenders is that agreement for an appraiser, an independent contractor appraiser, to do an appraisal carries with it a transfer of the copyright. So it's very common in an agreement between an appraiser and an AMC, for example, for the appraiser to agree that, hey, I'm assigning you the rights to that appraisal report. That's the simple way of taking care of it. So transferring ownership, or maybe not even transferring ownership. It could be a transfer of a license. You can use this appraisal report for whatever you want. So a lot of agreements phrase it that way.
Well, I know that in that period when there was a lot of discussion about this, appraisers were inserting language in their appraisal report that said it's copyrighted. Well, needless to say, that's a guarantee that you won't be engaged for any kind to do appraisal work that has to do with, mortgages, because everybody's going to use the data for collateral risk analysis, which is entirely what they got hired to do.
And there was a case that touched on some of these issues. It was the case where the appraisers were objecting to the use of data out of appraisal reports that were going through an appraisal portal, appraisal port, I think it was. And there was litigation over that. So appraisal port redid their agreements with appraisers, and appraisers specifically said, I agree to this. I assign, I'm giving you the right to use that data now.
Right.
And so that's very common now to see that kind of language in any kind of appraiser services agreement, contractor agreement. It's not just something you'll see with appraisal port. You see that in many types of agreements now.
Okay. Well, Peter, this has been really fascinating. As always, you are a font of knowledge for all things risk and liability related in the appraisal space, and we appreciate you bringing us this topic today. Keep us abreast of it as this develops, if you will.
I will. It's
all
something
right.
that it's a fun thing. It's a fun case to watch.
Okay. Fun for you. Yeah.
All right. Okay. Thanks, Joan.
Thank you, Peter.
ProxyPix is the first of its kind on-demand system for getting location-specific media you need from wherever you are. Their simple-to-use platform creates an online marketplace matching people needing property photos with proxies or data collectors near the requested location. Through crowdsourcing, you can get current up-to-date photos of anything on the map within hours, if not minutes. Never before has it been quicker, simpler, or more economical to get the property photos you need. Sign up at proxypix.com or download the ProxyPix app, available on Apple and Google Play Store. Thanks, Peter. Thanks, Joan. And what an interesting topic. Any listeners out there, you may want to check out our YouTube for this episode and see the floor plans that Peter was talking about. We're really interested in seeing the outcome. So thank you all for listening, and join us for our next one. Thanks and have a great day.